Welcome to Legacy Unscripted, sponsored by Progeny Coaching. This is the podcast where sports and business collide. I'm your host, Russ Katzman, and here we'll skip the fluff and get straight to the hustle. From athletes turned entrepreneurs or some of those impact-driven business leaders, we dive into the wins, the lessons, and some of those failures that make legacies worth living. Today, I'm happy to welcome Joseph George, co-founder of George & George Alternative Dispute Resolution Group, an international arbitrator and mediator. Joseph, thanks for joining us.
Thank you so much, Russ, for having me here. It's a great pleasure to be here and speaking about ADR and anything else that you can throw at me except the kitchen sink.
Well, I won't throw the kitchen sink, but we've got plenty to cover in a short period of time. First of all, let's start with Alternative Dispute Resolution, ADR. Why is it important to you?
It's important to me because I like to assist people in resolving their disputes, whether it's be arbitration or mediation or helping businesses negotiate contract deals, mergers and acquisitions. So I take that very personally. Grew up as a child in a household of 10 kids. Negotiation and mediation was always on the forefront of everything that we do in the house, whether it's trying to get the last cup of orange juice out the fridge or the last meal out the pot. With family, it's always a negotiation or mediation within the realm of household. So it's always important to me, helping people see that there's other opportunities that they can do, especially in the realm of business where, somebody's suing someone. Litigation is not always the recourse for going out and taking somebody to sue somebody. You have mediation, and arbitration is a quicker alternative to the option of litigation. So that's why, it's great for them to use these other options to resolve the dispute outside of court, where it's more private, it's more confidential than the litigation process. And it's definitely a huge cost saving on their part.
Gotcha. So, I just can't get past the 10 kids part. I'm the last of 6, and that's a big enough family. I can't imagine 10. Where are you in the pecking order?
I'm the middle child.
Right in the middle. Ooh, that's tough. No wonder you had to arbitrate both ends all the time.
Yes.
Talk to me about the types of clients you work with. Who do you like to work with, or who are you targeting right now?
We work we work with everybody. But our biggest clientele is usually construction, and we have celebrities that we work with. And, people with high net worth. So you could have the guy who owns the yacht. They have the big house, and things like that. And let's say he has a dispute with his wife, and they're breaking apart. And they'll call our firm in, and what we do is we work on the assets. They may have an attorney that's working on the divorce part. We work on the dissolution of the assets. So we figure out, like me personally, I give them a list, your must-haves, your haves, and your not-so-wants. And then once I get both lists back from both parties, I negotiate off of that, which I usually start with the must-haves. So if it's, we can't just split an animal in two and say, hey, you take this half of the dog and you take the other half of the dog. So that usually gets a little bit tricky, especially if both parties have a serious bond with the pet, so what they call them family members now. So if they have a huge bond with the dog or the cat, it becomes a little bit challenging there. But if it's the house, more than likely, that's easy for me. We could split the cost down the middle, or we could go, 70-30, which way they want to split it. But at that point, I would get a realtor involved, have them, do the equity in the house and, things like that, just to make sure that the client is happy. So, high net worth disputes, we love that. Construction disputes, we love that. Construction is very big because we're here in Florida. So here in Florida, they're building like crazy. Just about everywhere in Florida, they're building. And a lot of those things happen where sometimes the homeowner don't actually pay the contractor. So then the contractor decides he's going to go out and he's going to put a lien on the home. So when they put a lien on the homeowner gets upset because now they can't sell the home. They can't get no refinance on the home because that lien is there. As long as that lien is in place, the homeowner can't do nothing with that home. So then they'll contact us and we will come in. And that's only if there's an arbitration or mediation clause within the contractor's contract. So they'll bring us in and we'll work with both parties to assist them in resolving that dispute. And then of course, we do unemployment. We're very big in the beauty industry, so we work with manufacturers on anything from the labs to product liability. We do that whole realm right there with the manufacturers. So we work on everything, and definitely mergers and acquisitions. So big firms who's buying up another firm, and something was not disclosed during the acquisition, and the other side feel like that should have been disclosed up, and money got involved somewhere. So we'll come inside, we look at the documents, and then we'll sit both parties down and assist them in resolving that. So that's pretty fun. It's usually sometimes with big firms you have 20, 30 lawyers in the room, so it kind of gets a little bit heated. But we know how to bring the temperature down.
Well, and that's interesting there because I tell people all the time, business would be easy if it weren't for people. Dealing with our clients, our clients or customers, our employees, our suppliers and vendors, et cetera, right? They've all got their own emotions that drive it. I would imagine mediation would be pretty easy, splitting things down the middle from an asset standpoint, doing it on paper. But there's emotions, there's attachments, there's that kind of thing that's a component of these mediation talks. So talk to me about the emotions. Talk to me how, stuck in the middle of these things, how do you deal with those conflicting emotions?
I take my emotions out of it, and when I'm dealing with attorneys, it's checks and balance that we play in those high stakes types
Mm-hmm.
of mediation or arbitration. So we usually try to set ground rules for both parties, and both parties, understand the ground rules of the mediation or the bylaws of the arbitration that we proceed in the hearing. So once they tend to tread over that line, we usually either pull them into a private room and have a nice little conversation with them and say, hey, we're here to assist you in resolving dispute, but you're escalating a situation that needs to bring the temperature down a little bit in the room, so we could find out the bigger picture of what's going on, so we could assist you in resolving.
Okay. So who typically will bring you in? Is it the lawyers that bring you in? Are you usually contacted even when an operating agreement is established? How are you brought into an engagement?
Sometimes it's all of the above. Sometimes it's the client who say, hey, I know this great arbitrator, and I think he could help us out. And then they'll contact me, and then what I would do is I send them out an engagement letter, letting the parties know who I am, who brought me in, the costs, the date and time of the hearing or the mediation. So yeah, so it could be the owner, it could be even the attorneys. The attorneys say, hey, you know what? I think we should just go ahead and set up an arbitration or mediation for this dispute, because they don't seem like we're going to resolve this on our own. So let's bring in an either arbitrator or mediator. And then there's two things that comes into play. There's what you call MEDOP. So MEDOP means that they'll attempt to try mediation first. If mediation fails, then they'll go to arbitration. Or sometimes they'll do ArtMed, and they'll try arbitration first. And if they don't like the outcome of that, and that's only if it's non-binding. So non-binding arbitration is usually the major tool that's used for the ArtMed. So if it doesn't work out in arbitration, then they'll come to the mediation and try to negotiate something a little bit closer to what the parties want in that realm right there.
Okay. So the non-binding arbitration is basically a suggestion. Here's how we would split it if we were going to do so.
Yes, and sometimes the attorneys use it as a tool, as because arbitrators, we pretty much like judges, and we're pretty much a judge and jury in arbitration. So when the parties come to us, they are presiding their case to us. So they're representing the case as if they would have been in the courtroom. So I listen to all of the facts of the case, the evidence, all the exhibits that they present to me. And then what I do is I listen to both sides, open and closing arguments, and then I base my arbitration award based off of the facts of the case, and a little bit of knowledge and common sense sometimes too, depending on the case. And then, sometimes if they'll see that, and some attorneys will say, this would be a good example of what the outcome could be. We was to go to litigation process.
Gotcha. So I'm now located in Vegas, a lot of high net worth individuals,
Mm-hmm.
several celebrities locally. If I ran across one of them and I said, they said they've got an issue, and I said, I know somebody, how do we get them in touch with you?
They could reach us on our website at www.georgeandgeorgeadr.com.
Okay.
Or they
Very
could reach
good.
me, or they could reach me on my email, Joseph at georgeandgeorgeadr.com.
Very good. And we'll get you to put a couple of those links in the show notes as well, so we make sure everybody gets in contact
That's
with those.
perfect.
So talk to me about building a business around this. What do you have for a support structure? What have you designed? How long have you been around? Talk to me a little bit about the business that you put in around this arbitration and mediation structure.
I put in, let's say, so I'm a certified paralegal too, certified hostage negotiator. So, putting all those things together and bringing it around is actually helps because the paralegal helps with knowing the laws, understanding the terminology. So when attorneys is talking in their legal lingo, I understand exactly what they're saying. So I could actually relate back to them and repeat back to them and hit them statutes. So that having that paralegal skill actually helps with when they quote in statutes, I actually have my own thing that I could look up and look up the statutes and understand the statutes and interpret it well when I'm talking to the attorneys and say, hey, I think you're interpreting that they're wrong. This is what they meant to be. And then if I bring up a past case that was ruled, let's say, by the Supreme Court, I could say Gary v. Costco, the Supreme Court ruled in favor of so on statute this exit B of so and so. So then they'll be like, oh, okay. And then they'll get it and then they'll kind of back down a little bit and then we could proceed with assisting resolving the case. And then when it comes to the hostage negotiation training part, that helps me to when the room gets so heated, the temperature gets so hot in the room where everybody's arguing and the egos get involved and egos get bruised, then that hostage negotiation skill comes in where I bring in my active listening skill and I bring in my de-escalation tools out of my hostage negotiation toolbox and bring the temperature down, let them see each other's point of view. Let's be professional. Let's resolve this. Let's get it done. And everybody gets to go home with something in their pocket versus one side feeling like they got screwed pretty much on the deal. So we want to make sure that the deal that they're making, everybody walks in with a little bit of something, and I like to say a little bit of happiness in their pocket.
Fair enough. So talk to me about the George and George part. Do you have a partner in this, and how did that come to be?
Yes, the George and George is my partner is my sister, so it's me and her who run it. We have attorneys who work with us that assist us in different areas. We have personal injury attorneys that work with us because sometimes they have things that they want to bring in that needs to be mediated. We work with HOA attorneys who handle a lot of the HOA and the condo association cases. So they have us on their roster. So if they have a HOA case, they'll bring us in to either arbitrate or mediate the case. Because right now the court says anything that's in the HOA right now, a lot of those have to go to either mediation first before it comes to the court systems. So, and I know the HOA is that's a whole big old, that's a
Yeah.
whole nother podcast by itself. How about
Yes,
that?
it is.
So me and my sister, we work hand in hand. We work for the different court system in Florida to assist with resolving disputes throughout the state of Florida. So we work in different court types, whether it's be arbitration or it be mediation. We assist the court systems with getting those cases off of the dock.
Okay. So I've got a number of family businesses that I know listen to the pod. Talk to them for a second around how you and your sister have made this work and what are some of the most important things to consider in a family partnership.
Ground rules. You got to have ground rules. You set ground rules and you set directives on who is going to do what, when, and where, and how. Have normal monthly meetings on what's going on in the business, what haven't they done, what projects are they getting, how are they doing to put the business out there in social media, what area are you weak in that I could strengthen you in that area. So we have those conversations. That way we could continue to keep the business going without any ruffles in it. Now that y'all, as any business, you're gonna have a couple hiccups every now and then. That's part of life. But it's how we overcome those obstacles when they do happen is what's makes you greater than you was the couple days before. So we are gonna have little squabbles as we always do. I'm the little brother, so it's my big sister. So of course, being the little brother, nobody wants to listen to the little brother because they still see him as the little brother. But in business, I always like to say you got to separate church and state when it comes to business. Family is family out of there, and when you come into business, you're a partner, and we're just gonna figure things out and make sure things progress without the public knowing what's going on behind the curtains.
Yeah, I think that's an important consideration in business because, especially for those that are younger, I've had people on the pod that were, in their 20s and they've got successful businesses already, right? It has nothing to do with age. It has to do with experience and drive and determination and how you apply your knowledge to whatever challenge is coming with the business. But I hear you on the younger brother piece because, as I said, I'm the last of six, and I know that very well.
Yes.
So talk to me maybe a little bit about some of the situations, some of the challenges that your business is going through right now. What are you seeing as you look forward to the next year or two that are challenges for you or obstacles that you know you're going to need to overcome?
Well, the biggest obstacle right now that I could definitely talk about is the public. The public does not know about the ADR and mediation, uh, arbitration mediation. They're still a little bit unknowing about those particular ADR tools that they could use before going to court. And that's because it's not publicized. There's no billboards, there's no marketing about it. So that's my greatest challenge is getting the public to know about it. So we have created explainer videos, marketing techniques to articulate what we need to say to the public and address getting this information out to the public. A couple other arbitration firms have seen what I've done, and they've called me up and asked me, say, "Hey, I've seen what you're doing," and I've given them, the template, well, pretty much the roadmap also on getting their practice out there, so we all could show the public this is what they need, so the publics could come to us privately instead of running to the courts, because sometimes they go to the courts and then the courts will send them to mediation to use the court system mediation, but they still got to pay the clerk of court all this money up front to file the case with the court. So if they come to us, they could save a whole lot more money. So the greatest challenge is the knowledge of the public knowing what ADR stands for, which is Alternative Dispute Resolution, and knowing what arbitration is versus what mediation is. They are two separate heads of the coin. Arbitration is pretty much a private courtroom outside the courtroom where you assist in where you have one person, an arbitrator, who decides the fate over both parties' case, versus mediation, where the mediator is assisting the parties in resolving the dispute. So the parties they are pretty much the ones who resolve their own dispute, not the mediator. So that's what we try to get everybody to understand what the difference between mediation and arbitration is. Now, if they want to do negotiation, that's a separate leg of the ADR pyramid. And the ADR pyramid, the negotiations are a little bit lower down because negotiation have a lot more skill set that you have to do to assist in resolving dispute, because negotiation is it has so much tools in the toolbox that you have gray areas, you have black areas. There's so much tricks to get people to resolve the dispute, depending on which negotiator they're going up to. Because if they pull a negotiator in to go up against another negotiator, then
Yeah.
it's a royal rumble. Um, but if you bring a negotiator in to go up against attorneys, negotiators are always going to win. Attorneys think with their head on the law, negotiators think on tactics to resolve the dispute. So,
You know,
so that's what we help the community to understand what the ADR pyramid is all about and how to use this as a wonderful tool, which is cost effective, and it's very private, and it cuts time in half. I mean, if you call an arbitrator mediator up today, you could probably have your case viewed and resolved by next week, versus you go in the court docket and you probably could wait a year, 2 years before your case is heard. And during that time, you're still going through the painstaking of your case.
I think it's interesting because a lot of times entrepreneurs or young business owners, when they start their business, they're searching for that one little area that nobody knows about, that blue ocean that
Mm-hmm.
nobody's swimming in yet. And I think what happens is they don't recognize, and I just had this conversation with some clients last night, they don't recognize that there's an education component of that. If nobody knows that blue ocean is there, that you have to educate the public, which means you have a longer ramp period. And quite often, and it's interesting because it's kind of contra to the fact that you want a blue ocean, but quite often you want to work with your competitors, as you said, with working with other arbitrators to help get that message out in front of the public so that they start to understand what it is that you're offering. It's hard for the broader community to grasp immediately to a new concept or a new idea when it's contra to something they've been taught for years. And so anytime you're in something different like this, that's why I find it so intriguing to get this message out there. It's forcing you to have to educate the public and get onto platforms like a podcast and get out there with content and disseminate your content on across all the platforms. Anything you can do to become a thought leader in this space and to teach the public more about ADR and the pyramid that's associated with
it. A lot of people don't know much about the pyramid of ADR. ADR, the pyramid starts with hostage negotiation, then you have litigation, then you have arbitration, mediation, negotiation, facilitation, conciliation. And a lot of top ADR professionals don't even know about the pyramid. They just see mediation and they just see arbitration. They don't know that hostage negotiation is on top of the scale because you're trying to save someone's life. You're trying to stop someone from committing a serious harm to others. So it's high stakes. So hostage negotiation and crisis negotiation is on the top of the pyramid for that reason, because it's high stakes, high pressure. You want to make sure everybody goes home safe.
Yeah. Well, and even, I mean, it's on the other end of litigation, right? So and it's obviously nobody's life is in danger when this situation comes, but there's times when litigation says company A owes company B several $1 million. Company A gets the verdict, and then they say, yeah, we're not going to pay that anyway. And they're basically holding that company's future hostage because that company B is waiting on this money to come through. It's never coming from company A. And it's essentially a hostage negotiation type of situation. How do we get company A to do something that they deliberately are not doing and don't want to do and have no intention of ever doing? How do we get them to come to the table and discuss it?
Well, that's why you have to know your competitor. You have to
Mm-hmm.
do your research. Once you do your research and your analytics on the company, then you got to find something that they need desperately that you have, and then you offer that to them. And once they see that everything in life is give or take, you have to give something to get something. There's no free meal in life. So as long as you have something that they want, you could bring them back to the table.
I like it. So, speaking of having something you want, um, there's this concept out here called AI.
Mhm.
And anybody may think, you know what, you're just dealing with facts, at the beginning phases of this. I could probably take the facts and throw it into AI and see how AI would split these assets. Is that something people are doing? How are you dealing with AI in your environment?
I look at AI as another tool, a friendly service that to assist in the business that we do. AI, like just yesterday, I did a mediation yesterday, and the guy was, he can't talk. He's getting ready to go into for he has cancer in his throat. So I turn to him and I say, go on, use ChatGPT. Type in what you need to say in ChatGPT. In ChatGPT, then once you type it in, there's a button that you can press because his screen went dark, so I couldn't see the text. So I tell him, when you type in your words that you want to, hit edit, hit the thing. ChatGPT is gonna reword it for you, and then press the voice thing on the side. Once you press the voice thing, ChatGPT is gonna read the whole entire information out for you. And with him doing that, now that's how we get to know what he wanted to say. Because he did not apply for a reasonable accommodation for the mediation, so I did not know what was going on until he tries his best to talk, and I could see he's straining to talk. So that's, again, the AI is another tool. I do cases overseas in Saudi Arabia, Japan. I do cases in Abu Dhabi, Dubai. So you're going to have that cultural and that language barrier all the time, even though a lot of those countries they speak English pretty well. But when they don't, you have AI that actually works in favor of doing the translation for you. So AI has come a long way, and it's just another tool for us to use. I embrace it. If you don't embrace it, then you're killing yourself.
Terrific. And I think that people that think of AI as a replacement for humans are looking at it all wrong. It really should be an augmentation. And I've had this on a couple pods, and I've been preaching about this for years.
It's an extension.
It's really an extension and augmentation of the people that are involved in the process.
Yeah, it's an extension of what we do. It's going to be there. You might as well use it. Even like for video editing, it does it for you. It cuts your time in half. So why would you not want to do something quicker than the painstaking of trying to do it yourself and sit there for 5 hours when AI could knock it down in a minute?
Yep. No, I agree.
So they just have to embrace it. I mean, AI is here to stay, and they just have to embrace it.
No, that's terrific. Now I know we're going to have to cut it short because I know you're going to have to go soon. But before we do, the big question for you: if you were talking to your younger self again, you had to give him the top 2 or 3 lessons that you picked up in business along the way, give me an idea what you'd say to him.
Oh my God. I would tell him not to grow up. These bills is at the door.
Yeah.
I said, try to stay young as much as you can. These bills don't stop coming. They come at the first every month. You try to stop them from coming, but they keep coming.
Yeah.
No,
that's true.
on a serious note, I would tell my younger self, be a little more disciplined and patient. Patience helps a lot. Always make sure that to leave the door open whenever you're encountering new colleagues or potential businesses. Always leave the door open. Never close the door all the way. So never reject people and say, "Hey, I'm never gonna do this." No, you never know, because life has its way of turning things around. I started off in IT, fixing computers and doing networking, and now here I am doing arbitration and mediation and being successful at it. So you never know where life's going to take you. So you want to always leave a door open. That way you don't have to knock. Sometimes knocking is harder than a cracked door.
I like that. Very good. Anything else that we didn't touch on today that you want to say to the audience before we let you go?
Look out for arbitration and mediation. Let that be your source of resolving disputes. Try not to do litigation if you can. I mean, some things have to go to the court, but when it comes to evictions, construction disputes, unemployment, contract, especially breach of contract disputes, arbitration and mediation is a wonderful tool that's going to save you so much money, and it just doesn't save you money alone. It actually saves the friendship or the relationship or the business. So you want to use those tools, because when you go to litigation and you go before a judge or jury, there's going to be a winner and a loser. There's going to be things that's come out about you in the court system that you never thought would come out. Or the other person would say, "Oh, I thought he was my friend. I didn't thought he would have brought that up inside a courtroom." Well, yeah, he did. He wants to win too, and his attorney wants to win. But when you are in arbitration or mediation, you get to say what you need to say and resolve that dispute. And the biggest thing I would say when you're trying to resolve a dispute, the apology goes a long way. Money. It's most of the time in mediation or arbitration, it's never about the money. It's about somebody saying you did not give an authentic apology. And I've seen in mediation many times where one person authentically say, hey, Mr. Robert, I did not know you feel that way. I did not meant it that way. Got taken out of proportion. I'm truly sorry. I apologize for the way this happened. I did not know you felt that way, and I apologize. And I've seen the guy goes, that's all I wanted. And he says, "You know what? can I dismiss this case? And I've said, yes, you could go ahead and dismiss this case. So apology goes a long way. So again, any dispute you have, just own it and just apologize. It goes so far.
Very good. Well, Joseph, it has been a pleasure. I appreciate you joining us.
Thank you so much. It's a pleasure being here with you, Mr. Russ, and your team.
Thank you. And that's a wrap for this episode of Legacy Unscripted. If today's conversation sparked something in you, don't just let it sit. Take action today to build your future. Make sure to subscribe, leave a review, and share this with someone who needs to hear it. And if you've got a story to share or you just want to connect, you know where to find me. Until next time, keep it real, keep it bold, and keep living your legacy.